as you can imagine, with friends like that and users who are that friendly towards us, we are hugely confident of our future. That Mike, of all people, should take the trouble and the time on a hugely busy time to fly over here from all the way from Florence to be with us today is a huge tribute, and we owe him a great debt. We look forward to continuing support. I'm very grateful. What we thought we'd do to wrap up this part of the day, if we may, to give you the chance of getting back at us, was to have a panel discussion, but it really is going to be to answer your questions. And I would ask, please, for Professor Lawrence Boo and Seok Lim to come and join me. They need no introduction, of course, from me. Professor Lawrence Boo has more chairs than there are in this room. I've given up counting the universities in which he is a professor, so he'll forgive me. His huge value that he's added, both on the working party. One of the greatest joys that I've had since I've been working here intensively over the last 18 months, almost on a regular commuting basis, is that I have had the privilege of making friends at a level that I could never have hoped to from my background. To have become friends with people like Lawrence and Seok has been an enormous privilege as well as a pleasure for me. Lawrence has been hugely kind to me in helping me to catch up with things I couldn't expect to understand. He was also, of course, the Deputy CEO and the Registrar of the Singapore International Mediation Centre, so has worn both hats and understands that side as well. Seok Lim needs no introduction after a spectacularly successful commercial career, almost as successful as our international squash career. The less said about the better, because if anybody ever dares to want to take her on, you're in for a bit of a shock, because she started eating at the world champions at the age of 13, and she is formidable in every sense of the word. The huge privilege that SIMC has is that we share our chief executive with SIAC, and that is, I think, a tribute really that could only be done in Singapore. The idea that the arbitration centre should be so welcoming to mediation that it will be prepared to share its chief executive to operate, to market, and to run both companies is a formidable tribute and a debt we owe to them. Mind you, only somebody like Seok could possibly take on those two jobs and run as brilliantly as she does, and that only she would be the first to say, because of the huge support she has from those two brilliant ladies who you've already met in Eunice and Françoise. So it is over to you. I'm unashamed. We were on the working party together, and we put this thing together, and we believe that we've done a very good job. We've worked very hard at it. I'm sure that there are mistakes, and I know that we've got a lot to learn. We would like to learn initially from friends like you in a reasonably friendly environment, but please feel free to ask your questions as critically as you would like and give us the opportunity of discussing some of your concerns, either about what SIMC is doing and intending to do generally, or if you want specifically about the Arb-Med-Arb clause. We'll think of a nattier way of putting it, Mike, you're quite right, but it is an invention of which we are extremely proud. Has anybody got any questions that they would like to kick off with? John Bishop. John, for those of you who don't know, was the senior partner of Vincent Mason, is now effectively the Vincent Mason partner who runs the China operation and controls a huge amount of litigation, arbitration and mediation that comes from probably, I think, the biggest employer in the world when you think that China State employs over 1 million employees. John. I was hoping that I could soften the question slightly so that you might think you were among friends, but knowing you, what is your question?
Start without actually a question, but as you said, I work mainly with Chinese SOEs. We have in China, almost no experience of the kind of mediation we're talking about today, but in the last 2 or 3 years, we've had 2 or 3 mediations which have been very successful. They've been because various senior people in Chinese companies have been prepared to take the gamble of something new, which is not always a good thing to do if you leave the China. And there's now, the word is spreading in China. I'd just like to say that at the start because it seems to me that the timing of your great initiative couldn't be better for us in China, so thank you very much for that. We do also in China have some experience, I don't because I don't practice Chinese law, but Chinese companies do, of arbitration that moves to a conciliation process because it's in our law, in their law in China. I think explaining to Chinese companies the Arb-Med-Arb process may be a challenge. I had the challenge of 3 years explaining mediation. So trying to explain arbitration and mediation in this format may be tricky. But the questions that will be asked will be, how expensive is it? Is this not a more costly exercise? There are 2 exercises now. Isn't this just going to cost more? Is it really efficient? Once I've prepared the arbitration papers, why don't I just let it go on to get a decision? And finally, are you sure that I can enforce the decision? Is somebody going to say, because we do in China, when somebody tries to enforce a decision against us, oh yeah, I didn't get due process because I didn't say everything I wanted to say in the arbitration. So I don't know if you could help me with those 3 in selling this process in China.
John, thank you for all of that. I think it's a hugely important point, which I know has been expressed as a concern by many people. Lawrence, could I pass it to you first of all, please?
Thank you. Yes, I think the question that you asked bring us really to the very product that SIMC has come forward with. Thank you. Has come up with. In fact, this is the very first product that we are talking about, AMA, arbitration, Arb-Med-Arb. The situation that you've experienced in China probably is when they have commenced arbitration and they go through a process of conciliation. If they fail, they go back to arbitration. Yeah. So that is, but it's not a structured format. What we have, SIMC have come forward to this particular product is AMA, Arb-Med-Arb. That you commence arbitration and it's stayed for a while. Maximum, I think the rules provide for 8 weeks maximum. And then you revert back to arbitration only if you fail to succeed. But if you succeed in mediation phase, in other words, within 8 weeks, and an award can be entered into by consent, and that becomes enforceable. So by this process, it addresses 3 things, the 3 elements that you have identified. Firstly, how more expensive it is. It's not more expensive than if you have gone through the full arbitration. In fact, it will be much cheaper, because the stage in which it's transferred or stayed for the purpose of mediation is when the response to the request for arbitration has been found. So it is a very early stage of the arbitral process, and you freeze it for stay for 8 weeks maximum, and if the settlement is achieved, that's all the costs of arbitration that you would have incurred. So there's saving of expenses. Yeah. The other one is timing. How much time do you lose, or how much time is consumed? A maximum of 8 weeks is all that would have been spent. And picking up from what Mike was sharing earlier about the 2 success stories, the settlement and 1 funeral, and also the question that the folks were in the legal, the expectation of parties in terms of timelines. I added them up. Actually, you're talking about, in terms of SIC rules, 30 days, and another 60 days, we're talking about 4 months. So it is, a settlement could be achieved in an AMA situation within 4, maximum 5 months, maybe, if all goes well. So that addresses the time issue, right? So I think this formulation that SIMC has come forward is an innovation that is addresses also a very important legal question. There are a lot of institutions that talk about Med-Arb, so you go to mediation, and then if you fail, you go to arbitration, and there are some institutions that provide for arbitration, and then go to mediation. But here we have a situation, if you have a mediation that's settled, so it's a Med-Arb situation, then how can then you commence arbitration? Because in order to have an enforceable award, you need, under New York Convention, existence of a dispute. If a dispute has been settled, you cannot technically commence an arbitration, because you can't have create a dispute when there's no more dispute, it has been settled. So a Med-Arb situation does not produce an enforceable award, whereas an Arb-Med-Arb, in the formulation that we have proposed in SIMC, would achieve the result, overcome the issue of the legal problem of enforceability. So I hope that answers your question.
Thank you, Tansi. Could you pass to Seok? Can you, from a commercial point of view, add to that?
Actually, the benefit of having someone as knowledgeable as Lawrence go before me is he said everything, so I can just nod and agree. But I'd just like to add one little point on the China thing. I think we've made very clear in our rules that on the Arb-Med-Arb process, the mediator and the arbitrator will be two different people. They will be separately appointed by the registrar of the SIAC, who's sitting at the back there, Eileen. And in SIMC's case, a mediator will be appointed separately by SIMC. And unless parties agree, this will generally not be the same person.
If I could say quickly I would not underestimate the value of being able to get a consent award. I mean, people often think that you can just if you're in an arbitration, it's easy to get a consent award. It's not. It's actually very complicated. Because, take for example, I don't know how, I haven't tried to work this through the math of how Seok would handle it, but we had an ICC arbitration where we tried to reach a consent award, but then you've got the ICC court, which is interposed. You've got the fee calculations, and everything. The arbitrators have to be compensated. I mean, there's a lot. We had to amend our contract to let, to take it out of ICC and have ad hoc arbitration. And then there was a complication where our mediator, we asked him to sign the consent award. Our mediator was Bill Marsh, great mediator in London. And Bill said, the mediators room will appreciate this. He says, I'm not qualified as an arbitrator. I said, Bill, nobody's qualified as an arbitrator.
Thank you, Mike, very much. You can see that the holy grail that we've been looking for some years was a mediated settlement that was New York Convention compliant. We are the only organisation that has found the answer to it. Others are frantically trying to copy it.
So we call it the Singapore clause.
And it is already in use, it is already being adopted already as I speak. It is an innovation. We are extremely proud of it with very good reason. It will not materially add to expense or time. It is a huge benefit. Lawyers won't like it much for obvious reasons, but the less said about that, the better. The clients will endorse it enthusiastically. Thank you, John, for the questions. Next.
Could we have some comment about what happens when the parties agree on an outcome that wouldn't normally be the subject of an award?
Yes, we're very conscious of that. Thank you very much. Because, of course, one of the benefits of arbitration, one of the benefits of mediation is you can provide benefits that are not justiciable. A lot of the things like goodwill, continuation of employment, continuation of business relationships, we see no problem in there being side agreements which are not part of the enforceable award. In order to be New York Convention compliant, the award, properly so made after there has been a settlement, will have to contain only that which is justiciable. But I don't think we envisage any problems. Lawrence, outside and beyond that, is there any reason why, as mediators, we should feel inhibited from providing the sort of extramural, extracurricular benefits that we're used to providing?
There should not be any limitation or restriction on a mediator in an AMA situation to assist the parties in coming up with solutions that are not otherwise justiciable or enforceable as in the form of the consent award. What will happen is the mediated settlement will be passed on to the SIAC with a request that the arbitral tribunal, which was earlier constituted, make an award as best it can based on the consent agreement of the parties. That which is possibly enforceable will then be formulated in an award. We also have in our rules, in our protocol, make a provision that whatever agreed in the settlement agreement will form part of the pleaded case and within the jurisdiction of our arbitral tribunal. So that there won't be a situation in which you file a claim for $10 million, and in the course of the mediation, apart from settling the $10 million claim, there are other ancillary issues that are brought to mediation, and therefore it's technically outside the scope of the reference, original claim. So by adopting the protocol, we have expanded the jurisdiction of the tribunal to include those claims and agreements reached in mediation. So again, we have covered those areas.
Mike, from the consumer's point of view, would you have any concerns about a mediated settlement that was an arbitrable enforceable award that didn't cover all aspects of what I might call the non-justiciable elements? Would that put you off the Arb-Med-Arb?
No.
Thank you. So, if you anything additional?
Two things. I just wanted to make a slight correction. The appointments of arbitrators at the SIAC are made by the President of the Court. It's just because I saw Eileen in the room and I thought, well, let's scramble, let me talk about Eileen. But I think Eileen wanted to say something a little bit about the consent award perhaps as well?
Yeah, basically I think the process, just to address Mike's question, is such that SIAC will stand as the one-stop shop. We have the finance department that will do all the initial collection advances. So a party seeking that Arb-Med-Arb will give us the deposits that will be channeled off to SIMC. And in terms of once the appointment process is done by SIAC, the file will actually be passed on to SIMC, and the arbitration is stayed for, as Lawrence has said, 8 weeks. That's how it works. Now, assuming a consent settlement agreement is reached and parties do wish to translate that into a consent award, that draft award technically should come back to us, right? And we would go through the normal standard SIAC scrutiny process, which I think most people know is pretty fast. It doesn't go through the entire court. It's a two-stage process where it will be funneled through counsel at SIAC, who will check the terms of the settlement against what was the initial notice and response file. And what we anticipate, because this is actually a new procedure, is that we will work very closely with Françoise and Eunice from SIMC. And that was the reason that Françoise was formerly a member of our team as well for many years. So she's very familiar with the scrutiny process. And I do envisage that we will have a bit of overlap in the scrutiny process. And that will then channel out to me or my deputy for a next level. So that process is usually pretty fast because it is a consent award. We will not, we generally for consent awards, we cannot reopen the settlement because sometimes that would destroy the settlement, right? So we will usually a maximum of maybe 1 or 2 weeks. And then costs will be done simultaneously.
I think what you're pointing out though is how complicated the infrastructure has to be below this to get to a simple process on top, and why this is not being done anywhere else, why you need to have mechanisms like these in place in order to be able to propose something and have something that's really viable.
Yeah, I mean, that's why everything runs at the same time. The moment, I anticipate the moment the settlement agreement is reached, the council will tell us, the cost determination process will start. And basically there's not much cost because all that we would have done in that scenario is accepted the notice, considered it, made an appointment, right? And by a certain point, we know roughly how much of that cost will be allocated to us. SIMC will have to coordinate their billings with us, and that will generally accompany the award in that 2 or 3 weeks that we take to review it. So I think in the past when we've had consent awards, the common trend has been that we move faster because we know that we need to strike while the settlement is hot. We've had many instances where the consent award came in at 6:41 and they said, we need this scrutinized now, 2 hours. And we do the best we can because we know that we really need to get parties agreeing to the terms. And we try not to interfere unless it's really important. Something that perhaps the parties didn't consider that may affect the enforceability of the award. So I don't think it will be a very complicated process because we are quite efficient in how we do it.
You are extremely efficient. SIAC is, in my view, the best arbitration administration in the world, second to none. I don't think it's following Europe, I think it's leading it. And we are hugely lucky in sharing not only the cooperation between the staff, as evidenced by what Eileen has said about our own staff and ourselves, but for those of you who haven't yet visited, you should, just the floor below in our little office. There is literally nothing that separates the two offices. There is an open door through which Seok and others walk on a regular basis. So there could not be closer cooperation, spiritually or physically, between those two organisations. No one else in the world can do that. Sorry, Danny.
Thank you. Danny McFadden Cedar. As most of us know, CTAC uses Arb-Med-Arb, whatever we want to call it. Now, CTAC currently allows for the mediator to be separate, to have a separate mediator and a separate arbitrator. CTAC also allows, I think it's Article 19 or something, allows mediated agreements to be converted into awards. I called them once and I said, well, what does that mean? And how long does it take? Excuse me, and how expensive? And they said, well, take about 3 weeks. And and we envisage it won't cost too much. And I said, well, what does review mean? And I haven't quite had an answer to that question yet. That's one thing. And I suppose my first question is, what is the difference between what CTAC offers and what you will be offering? But the second part is, will you review the mediation agreement? And what, if you are going to do it, what does that mean? And how long will it take for a mediated agreement to be converted into an award?
Ross, would you like to take that first?
I think I can't answer for SIC. I would. It's still not on. Anyway, I think I can speak louder. Your first question about CTAC. The traditional CTAC method is to have the same set of arbitrator hearing the arbitration and then mediate the matter, and then if it settles, make an award in the course of the arbitration as part of its duty as an arbitrator. Because of its dramatic influence, they do that kind of thing for many years. This process that you have suggested that CTAC is doing, allowing parties to go out for mediation and coming back, is something new. Yeah, it's something new. Yeah. And your question of whether or not they can, they are agreeable to have mediation agreements being converted into awards. That question, if it is without commencement of any CTAC arbitration, purely a Med-Arb situation, I think you will suffer from the enforcement issue under the New York Convention. Yeah, so that remains a problem. If it is within the CTAC, the new process in which they allow it to be out for mediation and come back for arbitration, I think that will be something quite similar to what we're doing here. Yeah. The other question you have is how long and what's the benefit of scrutiny and it takes for the award. Here you are when an award when a consent an agreed mediated settlement is to be converted in an award, what it requires is for arbitral tribunal to be satisfied that it falls within the jurisdiction of the arbitration agreement or the agreement of the parties. It also has to ensure that some matters which are to ensure that the relief or grants made in the award are enforceable by law, justiciable, or make sure that no third-party interests, for example, are impacted or affected by the agreement of the parties. It's not an agreement to be converted an award so that third parties are in any way affected. It must not be against public policy. So these are questions that arbitral tribunal will have to apply its mind to when a party comes forward with a settlement agreement. So, but the SIC registrar will have a different role. Theirs is merely on form and a procedure to make sure it's adhered to and the rules are complied with, the protocol is complied with. So their check is different from what the arbitrator's role is. Arbitrator does have a role. It does have a role. It's not just rubber stamping. To assure those lawyers to see that this can't be a situation in which the tribunal just rubber stamp anything that the parties will come forward to rubber stamp and make it an award and terrorize the world with the award. So we want to make sure that that system, that those checks and balances are in place.
Thank you very much. Anybody else want to add to that? Time for perhaps one more? Where have we? Yes, Sarah. I'm so sorry. Either. In order. 1, 2. Yes. I'm so sorry.
I'd like to address the issue of enforcement of mediated settlement awards. From what we understand from today, the proposed Mediation Act will provide for mediated settlement awards, or rather mediated settlements to be enforceable in the same manner as a court judgment. And mention was made that UNCITRAL is considering this. Well, the paper was tabled by the US delegation in UNCITRAL in New York in June of this year. It is still not on the UNCITRAL agenda. It is being proposed for the UNCITRAL working group on arbitration and conciliation. But the Commission has not endorsed that particular initiative yet. But of course, the fact that the paper was proposed led to some corner discussions among various delegations. And the questions were asked as to how far does this extend? Now, coming from GE and big corporations, where normally you're involved in big commercial disputes, it does make some sense for a mediated settlement to be enforceable, because normally mediated settlements in the form of a quantified sum. So there's a quantified sum. But mediations can be settled in any number of ways. For example, I had one instance where the mediation resulted in a settlement which was a quantified sum plus a jug of beer. And in Gavin's case, for example, the settlement was not just compensation, but also getting his job back. And I wonder whether this can be enforced in the same manner as a judgment of a court.
Well, I think with respect, that was the point, wasn't it, that Jeff raised. There will be non-justiciable elements which will still be enforceable by private contract. The huge advantage that we think that we've got, and that nobody else has, and not for the first time we beat UNCETRAL. UNCETRAL takes a little bit of time to catch up with the SIMC, because the SIMC is an infinitely more efficient organisation. Nobody is surprised that they're lagging behind. We have already got an enforceable system. The reason that we've got it is we ensure that there is a real dispute at the time it goes to arbitration. That dispute is referred to mediation, so that when it comes back for the arbitration award to be made by consent, there is a dispute at the time when the arbitration came into existence. So the old objection and the problem that Seok ran into of having a sham arbitration award, because at the time that the arbitration award was made, there wasn't a genuine dispute, it was all over. That's why the importance that Eileen drew attention to as well, and Lawrence, there has to be a bona fide dispute at the time that the arbitration is commenced and then adjourned or stayed and referred to mediation, so that it's valid. But it's a valuable point. Thank you for reinforcing it. Sarah McLaughlin, I'm so sorry.
You're not, it's not the point. It is not enforceable as an arbitration award. The proposal is that it be enforceable as a mediated settlement.
Yes,
it
yes.
is Med-Arb is not
The mediated settlement, the part that is mediated settlement, may have justiciable elements in it, like a sum of money. It may have non-cooperation, non-rubbishing clauses in it as well, which are not justiciable. All that we are saying, all of us with one voice, is that the justiciable parts that are capable of being enforced as an award, New York Convention compliant, will be. Those that are not, obviously we can't wave a magic wand over, but they will be as enforceable as they always were as an mediated agreement. I don't think we can take it any further than that. Cyril, I'm so sorry I kept you waiting an awful
No, I'm freed up my trip, yeah. I have a variation offer on Arb-Med. Sometime back, the Chief Justice appointed me as the arbitrator. They told the parties, tell him I also want him to function as mediator. So you can't disobey the Chief Justice. So we worked out something with consent of parties. I sat as arbitrator. We had 4 sessions. I then wrote out the essence of the award, put it in an envelope, signed it, sealed it, the parties' counsel signed it. Thereafter I said, well, we are now in mediation. Whatever you say to me, your disclosures are not going to affect the award is there. For 4 days, counsel, plaintiff had argued on rate of interest. He said, I need 20%, the agreement says so, you can't dilute it. In mediation, I said, where are you in interest? It took him 2 minutes. He said, give me 10%, I'll take it. Defendant, 6 months he wanted damages. Where are you? 3 months. We settled within half an hour, 15 minutes more to drop the agreement. And I think there is an advantage because parties know where they are in arbitration. They know what the arbitrator knows. The award is there. It can't be varied. They are free to make disclosures. So I think it's an interesting variation. One last comment, Michael. If you had asked somebody in India how long arbitration takes, normally, eternity, expedited 1 generation.
By the way, and we can have an offline conversation about my experience with arbitration in India. By the way, we had one case where the Chief Justice Menon was appointed as a replacement arbitrator, and its arbitration in its 8th year all of a sudden settled in that year as soon as he came on board. So different value. What I want to say, I would point out, the UNCETRAL convention that's being discussed, I think, it illustrates the challenges also that you're going to face here in Singapore with this initiative. Because it's true, it is not yet on the UNCETRAL agenda. It's a proposal that's up there. It is facing fierce resistance from the old guard of the international arbitration community who know or feel that this is a threat. And I don't expect you're going to see them getting on board with an initiative like this one. But parties are strong. In fact, if you look at these disconnects, you'll find parties are heavily in favor of it. And why is that? Well, if you go back 50 years when the New York Convention was signed, where was international arbitration? It was practically at ground zero, whereas today it's a booming industry. So what does a convention like this do? Irrespective of the legal implications, will it help, will it not help, is it will promote international mediation. So I expect we're going to see a war on that, and we'll see how it plays out.
I think just to follow, I think Mr. Jeffrey Chan did mention that this paper has been highlighted or raised by the US. And I think you agree that it will take time, right? At least 10 years before anything real will come forward. I think, next year, will it be on the agenda, and how long will it take? Yeah, efficient. We hope that, because actually that will be a positive development. If actually there is a convention or even a model law on mediator settlement agreement, it will be a great leap of faith by those by a lot of people. You know, it will be good if that is, and also to pick up on the mediator arbitrator mediator situation. Of course, in many jurisdictions we are, at least those of us who come from common law jurisdiction, we're very afraid of this hybrid or monster called the arbitrator mediator. But in your case, I think you are the angel. You are able to help them with it, and they are very happy that magic works. But it will be a tough one. I have actually personally tried arbitration as an arbitrator and sitting as a mediator and reverting back when it was not resolved. It's very difficult. It is a very, very difficult one to split your personality, taking different roles in the same with the same parties. In your case, you did the magic and you settle it, and that's very good. Yeah, but in those cases, per chance you don't settle, what will happen? Yeah, what you've heard, are you like judges? They can erase it off their memory. Yeah, we are mere mortals. It's very difficult for us.
Lawrence, I'm hugely grateful. Until the Chief Justice arrives, there are only two people I'm really frightened of in this room. There's the Chief Executive, Seok, sitting on my left, and there's Eunice Cho sitting in the back of the room, and there's no way I'm going to come between those two and survive, so I'll do what they're both frantically gesturing at me. We're out of time. I would like to thank the panelists very much, but they would also like me to thank you for showing such an interest. We do believe we've done a good job. We're very proud of what we've produced. We are not complacent. We are waiting for your criticisms and hugely anxious and willing to discuss them with you with genuine modesty. So please use the rest of the time to attack us and speak to us privately, and we'll try and respond. Other than that, thank you all very, very much for your participation. Can you just tell me, I'm out of time on where we are next, Eunice, or where are people coming now? Thank you. Okay. Wrapping up now. In that case, you can tell us where we go from here.
Okay, thank you everybody, and thank you Edwin and our panelists.